Ciao. Hello, hello, hello. Hello? Hello?
Hello. Hello, how are you? Christian here. Ciao, professoressa.
Ciao,
Elisabetta.
come stai?
I'm trying.
Molto, molto bene. Sono così lieto di rivederla e parlare altre volte con lei.
Bene, sono contenta.
Spero tutto sia bene
Sì,
a Italia, alla
sì,
tua casa.
incominciamo, le cose incominciano ad andare un po' meglio. E lì da voi? Da voi?
Tutto bene, ma come lei ha conoscenza qui al Perù, come una democrazia debole, non ci sono le condizioni per per un buon servizio di salute. È così difficile. Sì.
Certo, sì. Speriamo che le cose migliorino.
Tra poco, sì.
Hanno tutti il microfono. Hello, David.
Hello, Elisabetta.
How are you?
I'm well.
Hi, Catherine.
Good morning. Oh, I can't believe this is working.
Yes, it
Hi,
does.
Catherine. How are you doing?
Very well. How are you all?
Fine,
Excellent.
thank you.
Thank
Fine. Hello.
Hello. This is my colleague Pierre. He's the tech guy at the university. So
Okay.
Very important.
Yes.
exactly.
On occasion today, I have take the time to shave my beard.
Oh, okay, good.
Otherwise, you may ask what that Hells Angels guy doing on my conference.
Yeah, and I pulled out my nicest shirt. I have to say, for the past 2 months, it's been very relaxed, right?
Yes.
In terms of the dressing.
Do you wear pajama from the waist downward? Because that's typical of. Hello, Gita.
No, not even. Anyway,
no.
it's
Perfect from the waist up and a little.
exactly.
Yeah.
No. Oh, hi, Vijita. Nice to meet you.
Hello, hi everyone.
Hello.
Hello.
Nice to meet you.
Good morning or good afternoon.
Good afternoon.
For us, good afternoon. Yes.
Well, I mean, this is really all sorts of times of the day and night, right? And I think the worst is probably David. I'm not even sure what time it is for you, David, but
yeah. No, it's at 11:30 in the evening.
Oh, okay.
On a Friday night.
Okay.
Well, so that's great. So you're done with the partying.
Hello,
so
Anna.
Yeah, that's right.
now it's good. Very good.
Hello,
Exactly.
everybody. It's nice to see you all. Yeah.
Yes.
Nice.
Hi, Elisabetta.
Hello, Richard. How are you?
I'm just waking up as David Bamford is just getting ready to go to sleep.
Okay.
It's amazing how the sounds is clear for everyone.
Yeah.
Yeah, it's
Exactly.
very good. In a few sessions we had before, someone was in a small room without just wall, and it looked like he speak in a scaphandrium. But the sound is very clear now. It's
Good.
No, and
Hi, everyone.
I'm hoping it will be
Hello.
Hi, Ale.
Hello,
wait
how
a
are
few
you?
more minutes. We're going to wait a few more minutes because we have, as you know, many people joining in today. And
Yes.
we're going to try to be, I'm going to try to be very organized. It's not going to be, you're not going to be able to speak as, oh, Yulene,
Hello, Yulene.
nice to see you. Anyway, so I've sort of tried to organize this event a little bit better with some order of speaking, and I know many of you will have many things to say. Some may have more to say, some may have less. I might not be of those who have more to say because, as you may know, Canada is not as advanced with solutions to COVID-related litigation. I think some of us might have more to say, but we're still going to try to stick to around 5 minutes each, so we can each get to say something, and then we can pursue on to sort of a wider discussion if we still have time and if we still feel like staying together. So let me see how many people we have at this point. Oh yes, we have a lot of
Hello,
people.
Jordi.
Hello, everybody. I see Santiago, Anna, I see Shana, Wolfgang, John, Alice, Bart, Janet, Hemis. Hello, everybody. It's so nice to see you all. So I think given that a wide majority of you are here with us today, and the technology seems to be working.
Hi, Hi, Sandra.
Hello.
I'm going to say welcome to all of you, and I'm going to ask you to stay on mute if you may. Also, be patient with me. It's actually the first time I organized such an event, and I haven't formally started teaching with Zoom, so I don't know exactly how it works just yet. But I must say that I feel very special to be with you. For me, it's the morning here, and I'm in Mont Tremblant, which is a famous ski resort in the Laurentians, sort of north of Montreal. And it's about 5 degrees Celsius, so we still are not very much into spring. But it is nice, and the snow is slowly melting on the mountain, and we're starting to see some birds and a lot of animals. So really the wildlife is all there here in Canada. It is a very special time COVID-wise as well, because as you may know, we're the 7th most dangerous place in the world at this stage, COVID-wise. So really, we're sort of feeling the burn at this point. This is Montreal. Of course, it's not the whole of Quebec. It's really Montreal. And fortunately, my family's been very safe. But I don't feel so positive about the pandemic at this point. The only positive side of things is to have you all with me this morning. So anyway, so good morning for some of you, good afternoon for others, and good night, and almost good evening, or almost sleep tight to some of you, such as David. So I'm very welcome to please you, pleased to welcome you to this COVID-19 and civil justice conference or meeting, gathering all of you scholars in civil procedure, civil justice, and judicial law from so many parts of the world. I feel like this is almost a miracle that the technology is working. This event follows, as most of you know, the efforts of Anna Nyland of the Arctic University of Norway and Bart Krantz of Leiden University in editing a first pamphlet on this same topic, so COVID-19 and civil justice. And many of us participated in this pamphlet. And the idea today is not to repeat the exercise, but instead to follow on their leadership by bringing the discussion to a wider audience and a virtual context and asking perhaps some slightly different questions. And I say this not because, I mean, they're not completely different questions, but I just think what's so special about the pandemic is that things are moving on extremely quickly. And in fact, what I wrote about Canada some weeks ago is not entirely true anymore because we're really sort of progressing very, very quickly. So inevitably, and like every sphere of normal life, existing dispute resolution proceedings, whether in national courts or arbitration or mediation settings, are already experiencing the impact of the outbreak. And where possible, hearings have been delayed or relocated. Courts and, of course, all the arbitral institutions and the mediation institutions around the world have looked to find solutions, in particular technological ones. And the pandemic has provided courts around the world with an opportunity to introduce new technologies and efficiencies to ensure greater access to justice, while, of course, protecting the health of and safety of all stakeholders. Now, of course, the integration of technologies and other software tools have also provided courts and legal professionals with an ability to integrate legal, actually, I'm going to say legacy processes and procedures. And so what I can tell you about Canada very briefly today is that there are still limited services in trial courts, in most trial courts, which is a bit discouraging. And this leads us to a great concern, I would say the biggest concern for an accumulating backlog and a true impact on civil matters. Of course, we're focusing today on civil justice, and what you must know and realize is that there are no jury trials and criminal jury trials at the moment. There have not been any, except for one occasion where, and this is only someone who briefly told me about this. Apparently there was one criminal proceeding via Teams, but otherwise there are no criminal cases being handled at this stage, which means that those criminal trials that have priority over civil matters will be handled first when the courts open again, and this will necessarily impact civil justice importantly. So anyway, on the brighter side, in the face of adversity, there's opportunity. There are many technical advisory groups being created, a national one at the federal level, some in BC, British Columbia, and also in Quebec. And I'm part of a group thinking about what to do next in terms of the organization of our courts. The codes and the rules of procedure around Canada and around the provinces provide for enhanced use of technology since many years, but the courts have been very shy using technologies, and now they're sort of faced with this, situation where they have to use technologies. So we're actually embracing technologies at this stage. There have been Zoom hearings in the British Columbia Court of Appeal, in the Quebec Court of Appeal as well. There have been, interestingly, e-filing that is mandatory for civil appeals in British Columbia and Quebec. There's live streaming in the Ontario Superior Court. Interestingly, on April 17th, so not that long ago, there was a live stream of a court case, and 150 people attended. So that's kind of interesting because we're interested as civil procedure scholars in respect of the open court principle. And of course, by having 150 attendees, that's actually many more than you would have usually in the court of justice. So we're actually providing perhaps more information and more transparency than we ever thought we would. Also interesting is the Supreme Court of Canada has announced 4 cases that judges will hear via a video conference in June. That's significant. This has been happening, I think, in the US Supreme Court as well. And a lot of situations with focused hearings, which help resolve an issue and move the case forward. More attention to the use of electronic evidence, e-filing. Again, interestingly, in the British Columbia Court of Appeal, there is a requirement that factums be hyperlinked to open source cases on Canly, which means no more voluminous books of authorities. So that's interesting, and I'm not sure we're ever going to go back to the way it was before. So with adversity, there has been change and modernization. Also, so a lot of positives there. Hold on 1 second. Pierre, muet. There you go. Okay. Now, many questions are still to be asked. What will the advocacy be like post-COVID? How will the technological integration impact the principles of justice, of civil justice, such as the rights to an oral hearing, impartial adjudication, the open courts principle, accessibility to the courts, physically, interpreters. And importantly, this brings me to my main question for today. What are the key elements to structuring a more efficient system of dispute resolution in a state of crisis? But more importantly, because I think the crisis has been, or the pandemic has been going on for a while now, I think we sort of have to start looking towards the future. So how are we to organize our courts to sort of handle the cases, the backlog that we have perhaps felt in our countries, and the increase in litigation in the coming months? We've seen, I'm very interested in class actions. I'm not sure if you've seen, but there are many class actions here, so in Canada and North America, many class actions related to all these travel expenses that we, of course, are familiar with as professors. And so a lot of class actions also involving those elderly in the living in special care facilities where the pandemic has hit a lot and very, very severely. There have been a lot of deaths in these facilities. So anyway, I can think of many ways at this point to handle the litigation, but of course there are many solutions to be found. Today we can talk, of course, about remote hearings and virtual courts. We could also mention ODR and case management systems and triage mechanisms, perhaps the adaptation of the rules of procedure for at least an interim period. So those are all many solutions possible. But without further ado, what I want to do today is sort of invite those of you who have made it in the order proposed, and I hope it's okay with you. I'm going to start with some that that feel that whose time zone might be a bit more complicated, such as David, for example, in Australia. And I will ask you to speak for a maximum of 5 minutes. I will try to be organized and show you the end of your time of speech when I have to, and I hope you will be understandable. I would like to also invite you to use the chat box. There is a converse or chat box option there in the bottom of your screen. Also, if you want to be heard, and there's something absolutely urgent you have to say, you can show your hand as well through the participants screen. There's a little show of hands there. And if that doesn't work, unmute and raise your voice. but let's try to keep some order. And I will start by inviting David to say a few words about the topic. Thank you. I will go on mute.
Thanks, Catherine. And hi, everybody. Nice to see you all. Basically, in Australia, we're very lucky where the COVID situation is improving. In my home state of South Australia, for example, we've had no new cases for 17 days, basically. And they're starting to reopen business and activity. And so courts, I think, are also sort of holding off to see how long this is going to go on. They aren't rushing to make big decisions at the moment. But what's happening in Australia basically is a continuation of the themes that I outlined in the summary for the pamphlet Catherine referred to. And what I want to talk about two things really in the time I've got. And firstly, as Catherine has already suggested, the move to electronic hearings and e-process is really solidifying very quickly here. In Australia, the higher courts are better set up to conduct virtual courts, as it were, partly due to our size and limit and population distribution. They have actually some reasonably good systems already in existence. The lower courts are really struggling, and they are basically suspending all non-urgent hearings at the moment. All procedural work's being done on papers or by electronic hearings. But the higher courts are continuing with trials. And what's interesting is the judges who are somewhat hesitant about it are increasingly liking it. And there's been a number of applications by parties to adjourn their trials on the basis that it would be unfair to have a video or electronic hearing, particularly because there are issues of credibility, and they say it needs to have a face-to-face trial. The judges are basically turning them all down and saying, no, we actually think we're doing pretty good with these video trials. Get on with it. And so, as Catherine says, I really do think, like online shopping, I think virtual courts have been given a big boost by the experience that our very conservative and technically perhaps not well-advanced judges are coming to terms with and getting experience. And I think that it's going to make a significant change in the process of, in the speed of change in the future. My second point I want to talk about is litigation more broadly. And in Australia, we haven't really seen, or at least I haven't been able to find any evidence of major COVID litigation happening. There are some class actions around, particularly around cruise ships, for example, and some of the outbreaks on cruise ships. But the most relevant one in Australia has actually been filed in the United States, not here in Australia, for a range of reasons. In California, Rick, I think. And so that there hasn't been any specific litigation as such. There has also been some legislative changes to protect businesses from decisions they make in the pandemic time. And so they've changed corporations law, they've changed bankruptcy laws. And so there's now some protection for businesses which will affect what sort of litigation might arise in the future. My third thing, going on for my second thing, in terms of specific COVID procedures, at this stage, it's only been one court that I know of that has now introduced specific COVID procedures, and that's our family courts. And that is because during March and April, they've had a 40% increase in workload arising out of urgent applications, mainly arising out of children and parenting orders. And it's quite understandable. I'm sure in Australia, there's been a big concern about the rise of domestic and family violence, dysfunctional families being locked up together in effect, and also problems with parents getting COVID and what's going to happen to the kids in those circumstances, especially if there's shared parenting. And the other problem in Australia as well, some of our states have actually closed the borders. And so moving children between states is no longer possible. And so they have had to adjust orders and parenting orders. So there's now a COVID list, as it were, in the family court. They give you hearings within 3 days, but it's all done electronically. So that's the only one that I'm aware of where it's happening. If I've got 30 seconds more, I'll say on public access, what's happening in our states is basically the public, if they want to log into one of these virtual courts, have to email and request the registry to allow them to do so to get in. And so that's how it's being handled at the moment here in Australia. So it's not anonymous. You have to actually say who you are and why you want to listen, basically, as I understand it. So that's a quick update from Australia at this stage.
Thank you, David. That's very interesting. So I'm going to move on to Yulin. And Yulin has circulated a PowerPoint, but I'm afraid I can't send it right now. I'm going to have to do this after the conference, Yulin. I really apologize, but at least you'll have some support. Thank you. Yulin, we cannot hear you.
Hello, hello. I'm glad I can hear you right now, and you can hear me. I've just finished this PowerPoint. Can I show you and share with you? May I share with you my PowerPoint?
Well, I'm not sure it will work, Yulin. I think.
Okay. Okay. I just talk.
I will try to circulate it while you're speaking, so you can just focus on what you. I apologize. I'm not very good at this.
I'm sorry.
But
yes. Me too. So I have some problems to. Can anybody start earlier than me so that I can adjust? I'm so sorry. I just come here and.
No problem. Why don't we ask Rick, if you're okay, you could go first and Yulin can go right after Rick. Is that okay?
Fine by me.
Thank you.
You can hear me?
Yeah.
Okay. I will try to adhere to the 5-minute goal. I can report on some things, but not on others. There's definitely a lot of activity in the United States. I am familiar mainly with our US federal courts. In March, our Congress adopted something called the Coronavirus Aid, Relief, and Economic Security Act, which as an acronym becomes the CARES Act, C-A-R-E-S. And back on page 618 or so, there is a directive to the federal court rulemakers to consider whether emergency rules or rule authority would be a good idea. There are also provisions about criminal cases. I know that's not our topic, but I'm going to say a little bit about those cases. The federal rulemakers have begun looking carefully at this. It's not at all clear that for civil cases, rule changes are needed because in our federal courts, almost universally, the courts have come up with ways to deal with the problems they have right now. Courthouses are generally locked up. Court staff are accessible online. And one big difference between the US and the rest of the world, or many of the countries covered in the report that was published with Anna and Bart's assistance, most courts, all federal courts and many state courts here have had online filing, not only as permissible, but required for a long time. So physical delivery of papers is important mainly for litigants without lawyers, and that's been an obstacle. Going forward, the reality is that for the US, and I think from what Catherine said, Canada, a big obstacle is jury trial, and the biggest feature of that obstacle is criminal cases. For the US, particularly in San Francisco and New York and Boston and in New Jersey, other places where there have been hot spots, trying to summon citizens to come to the jury service is a major concern. that the courthouses have been locked, and if you're going to tell people they have to come and hang around in a room with dozens or hundreds of other people awaiting jury service, that's not going to work very well. So online alternatives have grown enormously in importance. As Catherine mentioned, our Supreme Court had telephonic arguments last week, and I think also this week. Many of our federal courts of appeals have been doing that. State courts in many states have been doing that. And it sounds like the residual impact of our lockdown, which is now ending its second month, entering its third month, something like that. The residual impact is going to be a change in practice much more broadly. Not just courts, but lawyers too, are going to be doing things differently. Now, the sticking point there is trials, and particularly jury trials. I think Catherine or somebody mentioned the question of, David mentioned in Australia, the question of face-to-face encounters in a trial hangs over all of this. We have, for criminal cases in our Constitution, a thing called the Confrontation Clause, which says the accused is guaranteed a right to observe witnesses while they are testifying. Our Supreme Court has ruled that even applies in a sexual violence against children case. The child witness must testify facing the alleged abuser. So trying to do that electronically does not seem like it would work. Making credibility determinations is a greater challenge. There have been efforts, and there are examples of what we call court trials, civil case, try to the jury, try to the judge, not a jury, trials being handled online entirely. My offhand guess is that is not likely to happen, but lawyers traveling long distances to go to court hearings is probably going to decline a great deal. And we have live depositions in this country. Those are going online also. And all of that adjustment will really begin adjusting, I think, after constraints relax, because then a change in legal practice is going to lead to a change in court practice. So where are the bumps in the road? Well, criminal cases that are set for trial under our Speedy Trial Act have priority over civil cases, so that's going to be a big load once things relax. The other big load that's coming for our courts is coming for our bankruptcy courts, particularly, say, in Texas, where the oil business is in terrible shape. If you add on top of that something like 30 million Americans out of work and many businesses that have been shut down by the COVID developments, there's going to be a lot of work in bankruptcy courts, and they're going to be handling that online also. So in terms of other litigation, which I think David mentioned, besides cruise ships, the big civil mountain that is coming is probably insurance coverage, business interruption litigation, and questions of force majeure. So to sum up, yes, things are going to change. Judges in this country are cautious, and lawyers are cautious about moving away from the traditional face-to-face in-court activity, but they're getting used to doing things differently. It's cheaper, faster, and, as Catherine says, more efficient by doing it online. And so that's probably going to continue to be true, and it may lead to some kinds of rule adjustments. Thus far, everything seems to go forward without federal rule adjustments. Forfeitures, foreclosures, and evictions have been put on hold in many states. How that unwinds is unclear. It isn't as though the rent is forgiven, it's just it's deferred. So maybe that's going to be the source of some more bankruptcies. That's a quickie view of the US.
Thank you so much, Rick. Before we move on to Yulin, is there any chance you can share a link to the work that's been done related to the CARES Act, just for ease of reference, so we can quickly sort of...
Well, there isn't really anything to share a link to right now. I mentioned to you that I have finally been given access. I've been for 24 years a reporter for the rulemaking body, been given access myself on special permission to go look at a list of orders that is compiled by our administrative office of the U.S. courts. That's just the federal courts, not state courts. Last night I looked at an American Law Institute session involving 2 state chief justices and 2 federal judges concerning the ways in which their various courts have responded to these things. That's not the same as a list, but it's about an hour's worth of interesting watching. I think I can probably get permission to send that to everybody, and you just look at it at home on your computer. Frankly, I have gone through many of the orders that are accessible, and it gets very boring very fast. So you're not missing much. Basically, it's court access, how do you file things, suspending time limitations, which is another thing that's come up in many countries, time limitations in our rules. After such and such happens in a case, you must do this other thing within X days. Some of the countries reflected in the report that the Arctic University published have suspended what we call statutes of limitations, requirements that cases be commenced within a certain period of time.
Yes.
Some states have been doing that. Our federal courts really don't have authority to do that. So they haven't been doing that. And most of the things in there would look just like the things you folks are doing. Our judiciary keeps deep, dark secrets that don't seem very deep or dark, and it's not clear why they're secrets.
Okay, thank you very much, Rick. That's very useful. So I'll be curious to hear Yulin now, especially given China has been so innovative with technologies in the courts. Thank you.
Thank you very much. Now, can you hear me? Yes. So I prepared for some data so that I can make myself more well understood, because of my English is so poor. So I trying to still show you some words. Now first, I want to say about the issues related to the COVID-19. As I just sent you, that we have a mechanism that for the hot issues, the Supreme Court can always issue some judicial opinions and interpretations to deal with the urgent problems. So during the 3 months, it issues so many compelling opinions. So I've just sent you most of the cases and the problems rising from the crimes. I won't want to, I have just sent you, so I just quickly come to the civil cases. For the civil cases, we have sent, the Supreme Court sent 3 of the rules, 3 of the opinions. It's in the last 3. It's getting the procedure of the trial and regulate the litigation online. Actually, the online litigation is not just start from now. I will give you some pictures that we start even early in 2016. So it's a little bit ripe the year before last year, we have sent or have issued a regulation on the litigation on land about the legal services, about the trial, about what kind of cases to deal with by this way. And we have many rules. So I will come back to the problem. Now I send you what we have done. In the cases, the safe cases might be influenced by this disaster. I list here, and I will send you. It's a long words. Actually, the case not yet come to the court. No. But only several types of the cases have been increased as litigation. It's the first one is a dispute of the stock rights. The second one is the patent and the trademarks. And the third one is about some capital lease and disputes of mortgage. So for other kind of litigations, there's no data. I've just get this data from the Supreme Court. Some friends sent me the data. By now, in the past 3 and 4 months, the number of the new cases related to the COVID-19 haven't been very hot. So many people are still waiting for some new policies, and some others are still trying to survive from the disaster. So they may need some time to file the cases and to deal with their transaction by the way of what's that? Okay, and for the procedure, I am show you how many cases we have been dealt with. This is the number that during the 2 and 3 months, the court are still working. They are working online, and since 2016, the Smart Court program have been started. So even the basic courts have the mechanism to deal with the cases on the internet. So during this 3 months, about around 30% cases have been done by this way, and even more mediation have been operated by this way. So the problem have been raised by the litigation about the hearing on the internet is not as good as face-to-face, but we have some rules to separate, to first to set the condition of start the processes online, and for the urgent cases we have a long list about the condition. I can send you. It's a regulation is issued by the Supreme Court. Maybe I will send you. And now I come to the rules. We have some rules. Yeah. Maybe I have used up all my time.
Yolanda, yes, you have used all your time, but this is so interesting. I want to tell you, thank you for the PowerPoint. That is very, very useful. I don't know if you can just maybe conclude in 1 minute, please.
Yeah.
Because there's so much to say, but
yeah.
And
because of my language, when I have an urgent time, I cannot choose what to say.
It's very difficult. Thank you, Yulin.
Thank you.
Okay. Maybe actually, before we move on to Alan, I just want to ask you, did you say 30% of all cases move through the Smart Court program? 30?
Yeah.
So
Even more.
1/3 of all cases.
Yeah. I just sent you by the message. You can see my all the number.
Okay.
Because of my language. So I have a good prepared by PowerPoint, but I'm sorry I cannot show you. I can send you all of you.
Super. Thank you very much. Yes.
Okay.
Whatever you share to me, I will share to the rest of the group.
Okay.
Thank you very much. We will move on to Alan now. Thank you, Yulin, again.
You're welcome.
Thank you, Catherine. Hello, everybody. And hello from Zagreb. It's so nice to see so many familiar faces here. I'm sitting here in a country which had only one new COVID case today. And all in all, we can say that our situation has pretty much improved pandemic-wise. So although we were supposed to have a gradual and slow opening, it seems that everything is exploding right now. So even the courts work now since this Monday. But this is probably the result of relatively well, robust and probably therefore also successful measures with respect to lockdown. Lockdown was affecting all areas of life, although, well, I can tell you, I could drive my bicycle around all days, but most of the businesses have been closed, shut down completely. And well, while this was good for the pandemic, we have only about 23 death cases of 23 casualties per 1 million, which is, if I'm not incorrect, about 6 to 7 times less than in Canada. This has, on the other hand side, had a pretty massive influence on all spheres of life. And on the top of that, and this is probably our specialty, I think that many colleagues will say a similar story, but on the top, we also had a devastating earthquake in the middle of the epidemic here in Zagreb. And this happened on 22nd of March, causing also the damage to the buildings of the Supreme Court and the County Court, and on the top of that, the largest commercial court, the Commercial Court of Zagreb, had to be moved from its building because the downtown buildings here in our city are all built in the beginning of the 20th century. And now many of them, including the court buildings, are now not useful anymore. So the court has to move. So what happened in terms of our court proceedings? First, well, there were many measures and also ministerial guidelines with respect to suspension, stay of proceedings, and also safety measures, which would apply in only very exceptional cases, very urgent cases, which were handled by the courts in the meantime. If I could, well, just wrap up what we have learned, and it seems that we also have two possible scenarios how to proceed further, an optimistic one and a less optimistic one. So what we have seen were some old type special measures and some new type special interventions. So one old school reaction to this epidemic was of, I would say, a demagogic nature, because the government has issued special legislation on suspension of most enforcement proceedings and bankruptcy proceedings for about 3 months. This is partly also connected to the fact that we have parliamentary elections probably in summer, because now the government is forcing elections as soon as possible. On the other hand side, we have seen quite some speeding up of certain developments. For instance, our courts are generally rather anti-technological. So the Code of Civil Procedure, which was enacted last year, had a special provision on e-communication, which had to come into force when the Ministry of Justice finds out that the conditions are fulfilled, a rather innovative legislative solution. And you guess what happened? When the epidemic started, the minister issued, although nothing has really changed on the ground, issued a decision that e-communication will now become the main and the only way of communication in civil courts. Also, we have seen a number of reactions on the local level. So the judicial administration has issued several guidelines, which got a certain, well, innovative touch within the context of civil law tradition, because they gave, first of all, a possibility to use means of communication which were so far not regarded to be legal, including just the plain email communication for certain cases. This is probably not right in line with the law, but it is a sign of innovation. And also, I've now seen a couple of situations where individual judges have started to hold Zoom hearings or WebEx hearings. And although there are very few judges, this is, so to say, a dash of fresh air in our judiciary. So just to conclude, well, we now have probably a situation which will soon come back to normality, unless we will have a massive second wave of pandemic. So what can we expect to see? I hope that we will see, and there is at least a track of hope that we will see more flexibility, that we will see more initiative at a local level. So far, our courts were very much centrally directed. Much less negative attitudes towards electronic communication. So although we all suffer, we have learned that orality generally has been overestimated in terms of, so to say, direct contact. I would like to have a drink with all of you individually now, but we can communicate, and we learned, and our students also learned that online communication can be almost as good as the direct communication in a live form. And well, this is what I at least hope that we will see. The other option is that just like people forget things very fast, everything what we have learned will be forgotten as soon as things got back on the same track. And I think although everybody states now, well, there will be a new normality which will be rather different from the old normality, I preserve my right to doubt it. Thank you.
Thank you, Alan. I feel so sad that we're not in Dubrovnik this year at this time of the year, huh?
Actually, Dubrovnik was scheduled to begin tomorrow, so I'm so very sorry that we will not be there from tomorrow. But
well, may I suggest, let's just pretend we're in Dubrovnik this time of the year. Close
yes,
our
I
eyes.
see Alice has already some nice background, and maybe I should have also put a couple of Dubrovnik photos here. But pay attention, the dates for 2021 and also the topic are already announced. So just like we have seen good news from Tromsø about 2021, I can also announce our conference in Dubrovnik in 2021, PPJ 2021. And
All
I'm
right.
waving to Anna, who was instrumental to announce good news as well.
Thank you very much, Alan. So I think on this note that there will be a new normal, and we can think about ways in which to be more flexible and more innovative. Let's move on to, and as you will notice, I have chosen to start in the order of speakers with our new guests, so not the original signers of the pamphlet. Frederick Vage from Denmark. I would like to invite you, Frederick, to say a few words. Thank you very much.
Thank you, Catherine, and good to see also some familiar faces, including Mr. Untitled. Thank you. Just a brief update on how we have faced this pandemic in Denmark. For the first thing, the first thing that basically happened was that it basically came overnight that we started to make the restrictions, and just before the restrictions were imposed, just before the first restrictions came, we made some major changes to the Danish Epidemic Act, because normally in Denmark you would be entitled to have compensation from the state if your business was closed. That would be an automatic compensation. We had legislation that was giving the persons a right to that compensation. What we had not thought about, and what the legislators had not thought about before, was that in fact the whole country in the whole world, but the whole country was shutting down at the same time. It was simply not to be foreseen. So we would actually have had the whole country being entitled to claim compensation from the state for all the shut down businesses. So what we used to have was basically a law which stated that if a part of the town, a part of a village, or part of a town would be shut down for the purpose of fighting an epidemic, then they would be entitled to compensation. Obviously that would not be possible for the whole country. So there we had to make some changes in the access to compensation. On the other hand, when they removed that right to compensation, automatic right to compensation, they introduced the health packages, where we in Denmark have really, the politicians have really tried to cover all areas of the business sector, including hotels, restaurants, all the shops that had to be shut down. And they have been under this very big scheme that Denmark has borrowed an immense amount of money to be able to compensate the restaurants for not being open to each individual employee, and the focus has been on basically protecting the individual worker. Now that has not yet led into too many disputes. We have not seen many legal claims, but they are coming in now, and some businesses will claim compensation from the state and say that they are entitled to this, and they will not be giving the compensation because they do not fulfill the requirements. And then it's expected that there will be many claims, and that will be something that the court system will have to deal with. So that was the way we've dealt with it. I mean, removing the automatic right to compensation, and then introducing these massive health packages one thing. As to the courts, I can say at my university we were quite fast to switch to Zoom conferences and Zoom teaching and using Skype for everything very fast. But that development has not been very fast in the Danish courts, and we've really not been able to take advantage of the technology. Most of the cases have been delayed until after the epidemic, and most of the courtrooms now have introduced plexiglass in the courtrooms. That is the way they have dealt with it. We have not been, even though we do have technology and it is available, we have not used it in much. To some extent, they have made some oral hearings written instead, and they have tried to come over it by that. But basically, we have not been able to change the traditional way that the courts function, even though we might have the possibilities. It has been very limited in Denmark. And the point has been that the courts have been now delayed for 2 months, and there's a huge load of cases that will have to be dealt with now. So we have not been able to switch to technology here to a great extent. Only in very few areas it has been possible to do so. What they have done is that they have, for instance, hired a great conference center, and then they have made a very big court where you have 2 meters between each judge and each layman, and that has been the solution. The solution has not been technological. So far as to this. So I'm working on a big project where we try to see the development of digitalization in each country, and we're quite ahead in some ways in Denmark, but for this COVID case, we have not really been able to use the technology, I must say. But yeah, one thing that came up in the discussions, and I was personally involved in a political well, basically a suggestion that we should be able to facilitate all these cases that were COVID cases in a special court, COVID court, basically, where we would deal with the special claims and take them out of the queue and then move it to another place. And that was being discussed by the politicians in Parliament, this idea of a court. But so far, we just don't know how many cases will come out of it. It will take a while. It will take some months before we see how big this caseload will be. And that will be very interesting to foresee. But bottom line is basically that although we do have the facilities and we do have computers and we should be able to do it, we have not been able to really change the traditional way of working in the courts. We have some very traditional courts, and they have preferred to shut down the shop for this epidemic.
Well, thank you, Fredrik. I think Canada is very much like Denmark in these ways. We have the technology, but the rituals are so strong, and the tradition is very much paper-based and presence-based. So those are very big challenges for us, for sure. Now, your special guest today is Helena Mark from Estonia. This is a professor you have worked on a project, and so I'd like to invite Helena to say a few words. Welcome.
Yes, can you hear me? I'm sorry I can't make the video work. So if you agree, then I will only speak. Perfect. You can't see my face.
It's perfect, Helena. Thank you for being there. I'm sorry I cannot see you. We cannot see you, but we can hear you very well.
Okay, thank you. I will start now. Firstly, thanks to our extensive electronic case management, our courts in Estonia have been functioning normally to a large extent, but most of the challenges that we have concern hearings or other oral procedures. We have the possibility to have these remote hearings in civil cases and administrative cases, and there have been made some procedural adaptations to enable the use of remote hearings in criminal matters as well. However, our judicial administration has given recommendations on how to organize work of the courts during the pandemic. And these recommendations foresee that the courts where possible, will handle cases in writing or postpone the hearing, or in case the case cannot be adjourned, the court shall conduct the hearing or other procedural act by technical means of communication, or just use a large courtroom. As I said, we have the means to hold these remote hearings, but they are not used to a great deal in civil cases. So many of the hearings have been so far postponed or cancelled in favor of handling the case in writing. Personally, I think there should be more use of these electronic means, but I'm afraid people distrust these electronic means, and they don't want to have these remote hearings so far. So although we have had this possibility and technical means for a long time in all the courts, but they have not been used very massively so far. And I don't know if this pandemic lasts longer, or there should be another wave of this. Maybe there shall be more use of the technical means, but so far it hasn't happened yet. Concerning the case overflow, we have not seen coronavirus-related cases overflow so far. But interestingly, there was a legislation, legislative process initiated last year to target case overflow, such as we have now in other countries. And this legislation has not been passed yet, but in principle, it enables to refer a case to another court of the same instance. And in addition, it enables to receive extraordinary assistance in the form of judges hearing cases in other courts of the same or other level. So basically, it means that we direct our resources to where they are most needed, because usually there is the burden of cases is lower in some courts and higher in other courts. So we can use the means we have in some less burdened courts to direct them to the courts that are more burdened, if you can take my meaning. So this is in short what I wanted to say. Do you have any questions?
Thank you, Elina. Well, I guess I would just be curious to, I mean, I don't want to ask too many questions, but this is regardless of the jurisdictional or the jurisdiction of the different courts, that they would just be able to transfer courts from one level to another, or from one jurisdiction to another?
I think basically, yes. It could be possible, but preferably in civil cases are heard by civil courts and civil judges, of course. But there is also a possibility in case we have like a huge caseload in administrative courts, then we can take some resources from civil courts, for example.
Okay. Well, thank you.
Sorry, can I just ask a question about that? Technologically, it's not used. You don't do it online. Still, it's physical cases, Helena.
Sorry.
Sorry, but it's still it's still not done online. It's still only just physical cases. It's the same kind of cases you have. You don't use technology to do these extra hearings.
We use both means. We use technical measures, and there have been held some traditional hearings. But we do use the technical technical means, but not as much as we could.
Okay. Well, it sounds like a lot of the same problems all over in our different countries. Also, what's interesting, what will be interesting to see with all your presentations is which countries are more litigious than others. Because to the question, are there more COVID-related cases than before? Are we seeing more cases related to COVID breaches and the like? For sure, in Canada and the US, for sure. The answer is for sure, but around the world, let's see what you all have to say. Thank you very much, Helena. And also I want to just answer Alan and say, yes, the Zoom is recorded and it will be made available to everybody. Also, what comes to mind now is I think I might ask you for a little bit of homework as you're, after you have spoken, if you think of a piece of information, written information that you can share about what you've talked about, that you could share with me and that I could share with the group, that would be wonderful. I don't want to ask you for extra work at this point, but just if you have a piece of legislation, ideally in English or in a language we can read, that would be fabulous. Thank you in advance. So I'm going to ask Christian to speak from Peru. Thank you.
Well, good morning to everybody. Bonjour or bonsoir. I am extremely happy to see you once again, familiar and friendly faces. So it is really nice to get in touch with you once again. Well, I will bring to you several concerns and as far as I would like to call some remarks or information about how we are dealing here with this situation at a judiciary level. So to begin with, I think that I can say that coronavirus hit Peruvian justice really hard because, let's be honest, at least in Peru, as a weak democracy that we are, such as other South American countries, I don't know, here we cannot say or speak in terms of basic public services. Actually, these services do not have any trace of basic because in some way, the absence of budget expected by the government to other branches rarely is executed. So there is a huge lack of budget from the executive to the judiciary branch in order to improve or to produce legislation for the betterment or for the improvement of procedural techniques and so on. However, as part of an effort to alleviate or neutralize the negative impact of the COVID-19, some wide sweeping amendments were introduced. For example, several acts by the Justice Chief Executive here in Peru, several acts as measures to prevent, counter, and combat COVID-19 and other infectious diseases and related crisis emergencies. So this package, these amendments include a package of measures, including some measures that can affect how court cases are processed. For instance, one of the main solutions or situations that we are facing here in Peru is the suspension of procedural deadlines. I think this sounds really logical and natural. Generally, under the civil procedure rules here in Peru, civil litigation, enforcement proceedings will not start to run, or if already in progress, will be suspended during and for as long as the state of COVID-19 epidemic emergency or the state of COVID-19 epidemic persists. So we have suspended deadlines and procedural terms in order to avoid to produce any kind of lack of defense or procedural activity to the parties. this suspension does not apply to deadlines in matters of urgency. And I should refrain matters of urgency. And I would like to point out what are those matters of urgency. For example, provisional arrests, custody of minors, injunctions, and more related to criminal justice. Civil justice, instead of criminal justice, has experienced a low degree of continuity or execution during this time of COVID-19. Well, this seems to be an oversight on the part of the drafters of these acts, these measures, as it means that matters of urgency do not include civil cases, as I was telling before, which, due to their sensitive nature, needs to be recognized in a short amount of time. In particular cases, I can imagine cases or files started by motions for injunctions. There is another particular field that I would like to bring to you, related to other matters. During the state of epidemic emergency or epidemic, no open court trials or hearings will be held, except those relating to matters of urgency described above, as I was telling, like criminal justice. But in civil justice, no open court trials or hearings will be executed or performed due to the suspension of the deadlines. Finally, I would like to point out that we are experiencing here in Peru, since I think 2014-15, just to conclude, Professor Catherine, several changes and improvements on technological platforms and virtual softwares in order to continue or perform or run the civil procedures by internet, by other platforms like Google Meets or Zoom. So we can also file virtually or electronic the claims before judicial courts, and also arbitration, commerce of chambers. As an arbitrator, I do have a litigation practice in arbitration. It is friendlier and it is easier to litigate in several commerce chambers of commerce because arbitration has this flexibility, and it's more it's easier to litigate in electronic means. So as Professor Susskind said in several books, I would like to think that here in Peru we are experiencing that the justice service is not a place, but of course it is a service. It is not necessarily to be considered as a place or courtroom, but a service that can be executed by this means, by internet or digitally. Thanks. Thank you very much. I hope I let myself understand.
Thank you so much, Ken. This is very interesting, and interesting that you mentioned Richard Susskind, as he's done so much on this topic, and he's not with us today, but he certainly is sort of with us anyway, because with his remote courts website and all his work with his latest book, I forget the exact name, of course.
Online courts?
Yes, a lot of what he has written is extremely relevant to our discussion today. Mm-hmm. So what I'm going to do now, before I ask Santiago to speak, is just to take a very short, fun break, 2 minutes, to mention sort of what is going on in the chat room there with a lot of discussion about cats and backgrounds. I want to say I'm sorry for Anna and the snow, even if I love skiing. We actually are getting rid of the snow, so that's absolutely fabulous. I want to say bravo to Alan for moving from his home office to a cruise ship and now to a very big library, it seems. I want to say, well, hi to Xandra, who's making all the smiles. And some of you I don't know yet with some acronyms. I want to welcome Federico. I don't know you. Welcome and nice to meet you.
Thank you very much.
Elena, thank you for, we're now seeing you by way of video, so it's great to see you. What else can I say? Alice had a very good view from his balcony, and I mentioned it and he closed it, unfortunately. So I don't know if it's because he did not want us to feel jealous of him, but he had a fabulous view from his balcony. Okay, enough joking. I know our time is counted and the clock is ticking, but this is very pleasant. I want to ask Santiago to speak now. Santiago is from Uruguay. I think Uruguay is a quite, maybe not so litigious country, but maybe there are some ideas there. So thank you, Santiago.
Thank you, Catherine, for the invitation. It's a pleasure to share this Zoom meeting with such appreciated colleagues. First of all, some words about the Uruguayan justice system and the pandemic. Our system is characterized by oral procedures, both in civil and criminal matters. Collective procedures or class actions have little development here in Uruguay. Unlike what happened in other countries, in Uruguay, most of the cases that reach the civil justice system are resolved by adjudication, and a smaller number of cases by settlement, like very different than Canada, for example. No? The Uruguayan judiciary has a very good reputation in the American and even global context, but it needs to seriously improve its management. Since mid-March, well, really we are with the courts without operating or operating only on serious urgency case, but the new normality will begin on May 19th. So we are near to start the new normality with the resumption of judicial services in all areas with the strict sanitary measures. When the pandemic surprised us, the judiciary, as it's happening in a large part of Latin America, like, for example, like Peru, has a vertical organization in the administrative area which focus mainly on direct attention to the public and the holding of face-to-face hearings. So the judiciary has not optimized the use of technology to substantially improve the provision of the justice services. So try to answer the question of Catherine regarding the measures to structure the judicial response to the increased litigation in the new normality. We can say that in the coming month, our system will have to face great challenges due to the health emergency and the increasing litigation, a big increase in litigation, bankruptcy, labor, problems about infringement of agreements. So here in Uruguay, we adopted some legislative and administrative measures in the recent days. First of all, a law just been passed to give legal certainty to judges, lawyers, and litigants regarding the suspension of procedural deadlines in situations that raise interpretative doubt. Second, the Supreme Court regulates the gradual return to judicial activity in all matters. Third, a prioritization criteria was determined. The idea is that the new activity of the court must be have an order in relation of the seriously of the cases. Fourth, to avoid crowding in judicial offices, a digital agenda is gradually being implemented by the Supreme Court, through which attorneys request a day and time for issues that require attending court office. So it's impossible now to go to the court. It's necessary to have a day and a time. It's like to go to the doctor, to go to the court to do all the activities. Five, the Supreme Court has designed a plan for the gradual incorporation of judicial officials, and health protocols have been issued in accordance with the international recommendations of the World Health Organization. 6, this is very new, yesterday, a pilot video conferencing plan was announced to be held in some court of the capital, and the general use of video conferencing was authorized for all the courts if the parties do not object. So the judge could propose that, but both parties must accept to go to a video conferencing system. And finally, the Uruguayan Bar Association presented a bill to Parliament, which is currently under study, to promote more generally the use of technology in judicial procedures. Really, our country does not present a serious situation of collapse of the justice system, because we have a reasonable ratio of number of judges to number of inhabitants. But however, in my opinion, the measures adopted in Uruguay are insufficient, considering the increasing of litigation because of the economical crisis that we are going to face. Finally, regarding procedural rules and virtual courts, the other question, our procedural rules have not been adapted specifically for the crisis of the pandemic. Our procedural rules generally allow the use of technology, but it's not very frequent to use that. For example, in recent years, electronic notifications have been developed, as well as the online follow-up of the cases, and the holding of hearings to declare by video conference are really exceptional. However, although Uruguay ranks second in Latin America in the ranking of government readiness for artificial intelligence, this has not been perceived in the judiciary. So I don't know what happened, but in the judiciary, we don't have an answer about that. We don't have virtual courts, and the submission of documents via the web is not enabled here. Well, this is a brief summary of the situation in our country. Thank you.
Thank you very much, Santiago. Again, rituals and a lot of traditions involved in facing these challenges. I actually don't see Soraya. I think she is busy today. She's on I think she's busy with another project. So I will move on to Sandra. If you want to say a few words, Sandra.
Yes. Thank you, Catherine, for organizing. It's super nice. I'm here in my living room. I see Alan has again changed his background, but I don't recognize this immediately. I did recognize the library where we were together early this year when actually the COVID crisis started. I'm in my living room with my daughter. I have 3 offices now in different places, but none at the university. And my daughter is finalizing a project on the influence of high school life in times of COVID. And she did an online survey and got 120 responses, and then she stopped it. And some of your kids also participated in that, because I forwarded the link so that she would have feedback from many countries. And it's very nice that we're basically doing the same for civil justice now. For the Netherlands, I will focus on the adaptation of the regime as a result of the COVID crisis, and also how it boosted the use of technology in courts. 1 month ago, my team and I also published a blog post on this topic, access to justice on conflict of laws and civil justice, and I can post the link later on if you want to. And also I had an interview 2 weeks ago, or a long talk, with the president of the district court in Rotterdam, where I'm also a deputy judge, on everything that is happening on the ground now. And that was super interesting, because she also presides the committee of presidents of the Dutch district courts. So she knows very well what's going on in all the courts in the Netherlands. What we've done in the Netherlands is, well, there are actually 2 stages, and we just entered the 2nd stage this week. Our courts closed down on the 17th of March, so almost 2 months ago. And this was basically 2 days after the lockdown, or intelligent lockdown, because it's not a total lockdown, in the Netherlands was announced. Our restaurants were closed and cafes, the schools were closed, musea, libraries, etc. The shops, and especially food shops, stayed open and had the possibility to stay open if they could do this safely. But then the courts also locked down after some incidents. And for instance, in Rotterdam, there was an incident where a suspect in a criminal case was spitting on judges and persons in the court. And then, of course, they thought, well, it's really time to close down now. We might have more of those incidents. So as of the 17th of March, what happened then is that there were some temporary arrangements were made, usually per court, but we only have 11 district courts with some sub-courts. So it can be done efficiently and more efficiently than in huge countries maybe. And what was done is to proceed with the written cases and limiting the oral hearings. Oral hearings could only be done in very urgent and very serious cases, and only be done online or through telephone conferences. So indeed, all physical, because the courts were physically locked down, all physical hearings were no longer possible. And those serious or more urgent cases were then qualified, some criminal cases, especially the first hearing, insolvency cases, family cases, and especially, of course, youth protection cases were very important. Our judges work from home now, all having remote access. We already had that. Also on my phone, I have a DG Pass that gives access to digital files. So our work was already digitized, and that makes it a bit easier. The hearings now are done through video calls or by phone, and now they're using the Skype web app. And if I have meetings with the court, that is Skype for business. And that's a secured one. Then in written cases, it was already possible, but it was not harmonized throughout the country, to submit documents online or digitally. Now in the act that we also have, there's a full possibility to send everything through a secured email system. So that was immediately extended to everything. Meanwhile, law has been adopted concerning the hearing through video calls and phone calls, and also the secured email system has been laid down in this law, and also some online possibilities of hearing cases. Now we just entered the second stage that entered this week, the 11th of May, and that also coincides with a gradual exit from the lockdown. So our primary schools have started again, and in a couple of weeks, also the high schools will be reopened. So it coincides with that. A new law then also entered into force, a temporary act that will in principle stay in force until the 1st of September, or can be prolonged, of course, when it's necessary. The courts have reopened this week on the 11th of May, but of course with all the necessary security measures. So we have a 1.5 meter distance. I know it differs a bit per country. It's 1 meter, 2 meters. We have 1.5 meter distance. So all courts have all the marks, etc., to secure that we keep the distance. For the act says that most cases still go on. So the written cases continue and the online cases continue as a general rule, but physical hearings can also take place, but only when they are deemed necessary. And that is when there is a personal interest, when it has a certain societal interest, or when, and that was also, that turned out to be very important in practice, where an online hearing appears not to be possible. And that's especially the case when vulnerable people are involved, and that's especially some family cases and cases where youth is involved. And then of course a physical hearing is very much welcomed and is then enabled. The public is not allowed still in the court, because that of course would lead to too many people being on too little space. And to back that up, of course, we have the interest in open justice, is that 3 journalists at a maximum can be present, and then they sort of represent the public then, so they can report on those cases, etc., to ensure some kind of hearings. What we have seen, that also came out of this interview with the president of the Rotterdam District Court, is that Dutch courts have been very flexible and pragmatic in saying, hey, we already had some digitization, but now we need to push things forward. So things were changed immediately. Everything that wasn't digitized was digitized. And also the more conservative judges that still liked everything on paper were forced at home with their ultra books to work online. And I think that was a very good learning experience for everyone. And we can also see that because everyone had to go online, and we all have more experience now with video hearings, telehearings, etc., that this will also be more used in the future and will boost the digitization of courts. What we also learned is that, but still vulnerable people, part of the population, does not have a computer or does not have adequate internet access. And in those cases, hearing by phone is also done, which is also criticized, because how are you secure, who's on the phone, etc. But then, yeah, in those cases where protection of youth, etc., are at stake, then they say, well, it's better to have something than nothing, and that's just to stop the cases. One very funny thing is that actually the backload of our cases has become less, because all those judges work from home and can finally work on all those written cases. We have a tradition of having quite many written cases, but because of having to go to court, all the hearings, etc., everything takes longer. And now that we were all locked up, all judges finally start to work on writing all those judgments and getting through all the paperwork. So some courts don't have any backlog at all, and some just a little bit. On average, I think about 80% of the cases still proceeds, because again, many of our cases are done in written anyway. Then a last word on the questions that Catherine posed as first, as to the impact we think COVID-19 will have on litigation. I think in the Netherlands, this will be relatively limited because we're not a very litigious country. There have been some urgent cases that unsurprisingly relate especially to soccer, because the game has to go on. And when clubs were the football organizations were faced with not being allowed to play, then they started some cases. We also have a new act on compensatory injunctive collective action. I also posted something on that, on the conflict of laws. And also this act, together with the rules that we had in collective redress, may be used in these cases. But the way I see it now is that it will be relatively limited because of the sort of intelligent lockdown that we had, and the safety regulations that have been quite strict, and also the social security that we have. So also small entrepreneurs, cafes, freelancers, etc., they were all compensated. I just read in the news that even students who have a delay can, in completing their studies, although everything is online and is facilitated, will get 3 months of their tuition fee back. So there have been, I don't know how the government will cope with that. It will have a long-term effect, but at least I think this will limit the individual or even collective litigation.
Thank you, Xandra. Well, actually, there's this type of litigation in the US going on right now, and I imagine it will also come to Canada, because it always comes to Canada when it goes through in the US. Thank you for those very positive comments, actually. I really enjoy your perspective as sort of on the other side of things. I think it will be interesting to see how judges feel about this change in ways of adjudicating cases. I would like to say that the website you referred to is the conflictoflaws.net. Is that what it is?
Yes, I will later on. I can post the things that you want or send it, because also, for instance, the judiciary has a very nice notice with all the documents and the laws. And there's even a video indicating, oh, we have the situation, but we still continue. This is how we facilitate you. And of course, even if you don't understand Dutch, you can at least see some of the things that are going on in the Netherlands. So I will send that.
That's super. Thanks for sharing. I just want to make sure everybody can read it. So I'll move on to Anna. Thank you, Anna.
There I go for unmute. Yes. Thanks, Catherine, for organizing this. And it's so good to see all of you. We're slowly returning to normal, and I just want to know how to fix the weather back to normal. We've had a snowstorm today. Yes, it sounds very odd, and it's very odd, but the winter one prevailed over the coronavirus. Well, we haven't won the war yet on the coronavirus, but we're returning to normal, sort of. In terms of litigation, first, we have very oral proceedings, and that's problematic. Having said that, there are clear differences among courts in Norway. Some have immense backlogs, particularly of criminal proceedings, and they keep building up. Others have found a new normal. It's partly a matter of technology. The Norwegian government has, through the EEA agreement, paid for installing video recording equipment in courtrooms in Central Europe, but we haven't taken the money to buy that for ourselves. And also some courtrooms are really cramped, so the 2 meters of social distancing has been impossible, and thus they have had to postpone hearings. However, now the distancing is reduced to 1 meter, so there's much more room. And also, it's very much a matter of culture, and some courts use the first weeks of lockdown to learn and teach each other different kind of case handling techniques. And have been much more successful in sort of learning how to do online remote hearings. And even the Supreme Court is now sort of returning to business as usual, where you have video links and then you can request a link to attend the hearing virtually or online remotely. We have had some questions, how far can you go with remote hearings? And for instance, in criminal cases at the first police custody or remand hearing, you should be able to meet in person, and then when they continue it, you might not have to have the right to attend the hearing. We also have in insolvency matters, we have never had any rules on Chapter 11, sort of restructuring on companies, and now we will have interim rules that I hope will turn into permanent rules. When it comes to, although we were not supposed to speak about ADR, I would like to say a few words on court-connected mediation, because the Norwegian Courts Administration wants to put on a program where you could mediate a case without the case being pending. So a judge would mediate without you first having to file a lawsuit, because Finland already has put that in place. So they want to investigate whether that would be a possibility, and I will have a meeting on them on Monday. And then when it comes to litigation, we actually have an ingenious system because it's very difficult to get a case to a court. Almost no administrative cases ever reach courts in Norway, and they go through all kinds of boards, and those cases we will probably only see very few of because the boards will have all the problem with how to hear all these cases. Small claims, then limit will be 250,000 crowns. That's about 25,000 euro. And any claims below that, you will have serious difficulties getting into court. So we've basically solved lots of our problems by not by having a very high threshold of actually being able to come to court. And of the cases that we see that are possible, for instance, class action cases, it seems that using class action as a threat actually has melted away some cases. So people have been able to access their rights without filing a case. And also the most likely way that courts will deal with those cases will be to take a pilot case. And then of course there will be, I think we will see massive labor litigation, but it will take months, or at least a couple of more months, for them to reach the court. So we will see what happens. But currently the main problem is really that there are huge differences among courts on how they handle cases, based on a lot of different factors, and one of those, as I mentioned, court culture, or how individual judges have adapted their working methods. So that was basically what I had to say.
Thank you very much, Anna. That's quite very interesting. I'm going to move along to a totally different place in the world with Hermes in Brazil.
Hello, thank you, Catherine. I am very happy to be here with you, and it's good to see some friendly faces during this pandemic. We'll brief trying to answer in 5 minutes the aspects regarding to Brazil in the questions addressed by Professor Pichet. The legislative and judicial response. We have now many laws and acts enacted by the government to regulate the COVID-19 impact. The most important regulation is concerned with health, financial budget, and economic problems. But there are few laws and acts that impact the judicial system. For instance, we have a draft that is being discussed in the parliament to prevent the future massive litigation for breach of contracts, regulating time limits, force majeure, etc. But it's still going on. The most important regulation, however, must be recognized to the acts of the National Council of Justice that since 19 March is suspended all deadlines in the Brazilian judicial system, federal and state courts included. Even with deadlines suspended, we have had judgments and some proceedings have been ended. Enforcement measures are maintained, most of all by e-service, and interim reliefs and urgent measures too. In total, we have 3 enacted acts by the National Council until now, and this is a new use of the Council powers. Management of COVID-related litigation. At this moment, we have more concern with the class actions than with the individual actions related to COVID litigation. But in the future, it's possible a massive increment of individual litigation because we are a very litigious country as United States and Canada. There is a possibility to manage this litigation with suspension of the individual cases for the judgment of the related class actions and suspension of the individual cases using aggregate litigation proceedings in the courts of appeal. Regarding the judicial review power, the general approach is self-restraint, even if we have some few polemic decisions. We are using the tag COVID-19 in the case regarding case recordings to case management the COVID-related cases. And we already have some public data about that litigation. We use also virtual courts, and we can talk some about the access to justice. the National Council recommended the progressive digitization of migration to the e-process. The process that are already e-process must to go on. That means that that where the files are already online, the e-process deadline started to run again. So since May 4, we have the process going on, the e-process. And must be concluded with taking of evidence, video conference hearings, and final decisions. Exceptions made only in the case of clear impossibility, ad impossibilia nemo tenetur. Regarding to on-paper proceedings, in all Brazil, the deadlines are now suspended until May 31. The acts of the National Council also recognize the diverse situation of many states in our continental country. As in Australia, it is a tendency in Brazil to look at the territorial difference. It's very clear that if we have territorial lockdown, this situation imposes the suspension of all proceedings on paper and e-process. On the other hand, we have some problems, as many other countries, regarding structure, personnel, and knowledge of technology. Also, publicity and safety issues are a concern. The official but not mandatory system recommended by the National Council was the Cisco WebEx, but many courts are trying Zoom, Teams, and others. Many initiatives are in course of action to improve ADR using ODR, starting with individual and spending to collective redress. Recently, we approved a new statute that allows online ADR hearings for small claim courts, but it's very, very common and we can use to all courts, I think. An important question is reinforce the procedural principles of fair process and orality. There is some criticism when the courts allow only video recordings and not real-time online presentations for the lawyers in the cases. I think that maybe the procedural agreements can have some impact in these cases, because with the agreement of the parties, we can move on with more security on that cases. Well, that were my considerations, and thank you, Catherine.
Thank you, Hermes. I think your last point was very important about procedural agreements. That might be a very good way to look at things. I worry a little bit because I hear from many of you this idea of having some cases that are more paper proceedings and more technological or more oral proceedings. And so I don't know that this way of sort of organizing cases is...
Yeah, this is a very interesting point. Jury trials, I think jury trials in criminal cases will be very difficult, have online hearings. So that will be very interesting. Yeah.
And also because some are proceeding before the others, it means that some are considered more important than others. And again, it's a way of organizing education that might be problematic. Okay, thank you very much. If you have some written notes that you want to share, that would be very useful as well, because those are very important developments, given the scope of litigation in Brazil, given the importance of litigation. I'd be very interested to read your
sent you.
Hermes, thank you. So moving on to John. I don't know if you're there, John. I don't see you right now.
I am, yes. Yeah, no, I'm here. Okay, well, thank you, Catherine, and Anna and Bart as well for starting this whole process. What's it been like in England and Wales? Well, to give you some context, England and Wales and the courts here have been taking a very leisurely pace over the last 2 to 3 years, possibly longer than that now, to develop online justice and online hearings. And over the last 12 months of last year, they were running a pilot scheme for online hearings. And during those 12 months, there were 2 cases and no more than 2 cases which went through that pilot. With the COVID pandemic, that all changed, and literally, and I mean literally, overnight, the default position for the courts in England and Wales were that all hearings would be carried out remotely. So we went from being quite, I suppose, resistant in a passive way to online technology and the use of it, to embracing it with a passion. And the position now is that in terms of the civil courts, at least, and the family courts, that interlocutory hearings, interim hearings, case management hearings, trials are all being held remotely. And that is that hasn't posed the problems in terms of the judiciary embracing it and the legal profession embracing it that we might have expected. They're all just getting on with it and doing it. And in terms of using a variety of different technologies, whether that be Skype, Microsoft Teams, not so much Zoom, and also an in-house technology which the court service here was developing and had been developing for some time in a kind of a test basis. But the coronavirus pandemic resulted in that being accelerated massively, and now that in-house court service remote platform is I think ready to be rolled out, or its rollout will be imminent. So a lot happened in a very short period of time. Looking at the particular questions that you asked, Catherine, in terms of management of COVID-related litigation, at the moment we haven't seen any. What we're anticipating, though, is that over the next 3 to 6 months, we expect a huge increase, I think, as Rick mentioned, in the States, of bankruptcy and insolvency litigation. We're also expecting a lot of insurance claims to come up. Also personal injury claims, whether those are personal injury claims against employers, but also possibly against the health service. So we're expecting a lot to arise in terms of the consequences on individuals of the pandemic. In terms of what is being done now to prepare for that, there is nothing in the public domain on that respect yet. The government, as far as I'm aware, isn't doing anything in that respect. The judiciary are working out themselves what to do in terms of what might be called recovery from the present situation, which is focusing, I think, on listing proceedings and on prioritizing particular types of case. So, for instance, possession claims, so landlord and tenant claims will be prioritized, for instance, or claims which involve damages for individuals will be prioritized. But other than that, there is no discussion which is publicly available to talk about that. So I can't really add anything concrete on that yet, but I'm sure that will become evident as the months go on. In terms of judicial or legislative initiatives, in terms of the overflow that we may expect, at the moment there is no legislation. We had legislation immediately which dealt with the immediate situation as it arose, but in terms of managing future claims, suspending limitation periods, for instance, there has been no legislation at all to deal with that. I would imagine that we could possibly anticipate the potential for future legislation as time goes on. If, for instance, there is a second wave of the pandemic, or it has an impact which is more longer term, which affects the through flow of litigation, then we may see primary legislation. In terms of the judicial response, I'll get onto that in terms of dealing with the other questions that you asked, because the immediate judicial response to the pandemic was, as you'll have seen in the document that Bart and Anna produced, was that the judiciary exercised its various powers to change court procedure. So they issued a raft of guidance, both to judges and to legal practitioners, informing them how proceedings would be carried out in future and how the procedural rules would be applied to cope with the pandemic. additionally to that, they issued what are known as practice directions here, which are quasi-court rules, to alter the process. So for instance, they imposed a stay on all possession proceedings. They altered the rules to allow parties to agree extensions of time to comply with procedural time limits. Now, that all worked quite smoothly, but what we are seeing now are cases challenging the exercise of authority to issue those practice directions and that guidance. So we're starting to see judicial review actions, public law actions, claiming that the judiciary acted ultra vires to do what they did to alter the court rules. Now, the very first of those challenges was before the Court of Appeal last week, and thankfully, from my perspective, it failed, and the legality of what the judiciary had done, fortunately, was upheld by the court, although some might say you might expect them to do so. But at least from that perspective, they were upheld. The other thing which primarily happened, and this stems from the movement to working digitally, working online, was that now we're seeing some evidence coming through as to the effect of holding hearings digitally. And what we're seeing, particularly from the judiciary, is an approach which takes them to the view, which I don't think any of them would have said 6 months ago, that they're perfectly able to hold trials online, even oral trials, maintaining the tradition in the common law, and that even in cases where witness cross-examination is central, one judge already has expressed the view in her judgment in a High Court case that it makes absolutely no difference as far as she's concerned to the ability of the court to assess witness credibility, to assess whether they're honest or not, to assess the nature or quality of the cross-examination, whether they're standing in front of them in a courtroom or the hearing is taking place online. I think, as she put it, if somebody's a good liar, they're going to be a good liar whether they're online or whether they're in front of you. So I don't think 6 months ago, 12 months ago, those type of views would have even been considered by the judiciary. So what we've seen is practically overnight, the judiciary embracing a form of technology and a form of hearing that we would never have expected, at least not in the short to medium term. But what we're also seeing is a consequence of that, because as I said, they're holding interim hearings, case management conferences, trials. We're starting to see some evidence about the effectiveness of the different types of hearings. So anecdotal evidence, which is coming to light at the moment, is suggesting that shorter hearings are more suitable for online procedures. And the reason for that seems to be that both the practitioners and the judiciary are starting to suggest that a 3-day trial or a 4-day trial poses much greater stress in terms of their concentration, in terms of headaches, in terms of just literally having to deal with the technology than actually being in a physical court. So what we may see as a consequence, and this is probably contrary to what Richard Susskind has suggested, is we may see a differential approach being taken in the light of the evidence that we're gathering now to the suitability of certain types of hearings for digital and remote processes. So we may find the 1-day or the 2-day hearing being the maximum hearing that will be dealt with online, and physical courts being reserved for the longer types of hearing. The other thing that we're also seeing, I don't know how much time I've got left, but I'm sure you'll tell me, Catherine. The other thing that we're also seeing is that the use of technology in terms of electronic bundles, electronic case reports, etc., has equally been embraced, so that to the extent that, again, nobody I think would have anticipated from the judicial side of things or from practitioners. So we're seeing those being used in the hearings in ways that they were never done before, even when we were starting to develop the use of them for traditional hearings where the parties would be in court, but you'll be using electronic bundles. So now we're seeing them being much more, being used much more often as a consequence and much more easily. The final thing that I would say is, what about the parties? Well, anecdotal evidence again, and more of this is being gathered, is that the answer seems to be that the parties tend to be, except with 1 or 2 exceptions, tend to be satisfied with the hearings, tend to be satisfied with the process that they have access to remotely. And again, that is perhaps something that certain individuals would have been skeptical about 6 months ago, 12 months ago. Now, there have been certain exceptions to that, particularly where cases have involved particularly sensitive matters, particularly family matters, for instance. The parties in those type of cases have seemed to have suggested that they were less satisfied with the process that they were afforded. But in general civil cases, we seem to see perfectly adequate party satisfaction with the process. So I think we've got a lot to learn from what's happened so far. I mean, I think probably the one thing that I can say in terms of conclusion is that I don't think the civil courts in England and Wales will ever go back to what they were before the beginning of March. I think the default will be for a lot of hearings in future that it will now be online using the technology that we have, rather than waiting for the development of bespoke technology by the court service.
Wow, John, thank you very much. This is very interesting. You probably have the most information to sort of reflect on the use of technologies in courts. This is really superb. So I imagine there are no more delays, or how does that work?
Well, there are delays in the county courts, because what tended to happen was, at least in the county court, is that a lot of the types of hearings that would have been held have been postponed. So, for instance, in the county courts, a major area of work they do is possession hearings, which are landlord and tenant disputes, and effectively the government, the one bit of legislation they did introduce prohibited those type of new claims in those areas being brought until the end of June, which is why there's going to be a huge backlog. And the judiciary also suspended ongoing proceedings from going forward for them. So a large amount of work within the county courts has been effectively taken out of them at the moment. So that's one of the areas where I was referring to, dealing with the backlog of those type of cases afterwards. But other than that, the work has carried on in the county courts.
Wow, that's okay. That's great. Well,
the one other thing I would say is that I referred to anecdotal evidence, but we're already last week a formal consultation was started to gain qualitative and quantitative evidence from practitioners and from parties on the use of online courts and online procedures, and that should be reporting probably by June sometime. So, and as I understand it, they've already had over 1,000 or so responses to that, which in terms of the usual type of evidence that we gather over here is again astronomical in terms of the amount.
Mm-hmm. Exactly. Well, that's interesting. I want to, so David, I think, wants to raise his hand because I think he might be leaving. I'm going to presume that, but please go ahead.
Right. Yeah, thanks, Catherine. Yeah, look, it's getting up to 1:30 in the morning here, so it's been a very fascinating discussion, but my bed has started to call towards me. But I did also, just a quick remark in response to John, we had one of the judgments here in terms of assessing witness credibility and the challenge by parties to say we want a face-to-face trial. The judge actually said, I can see the witness a lot better on the video conference than I can see them in my courtroom sitting 5-6 meters away, and dismissed the application out of hand. So just confirming your view about how I think things are not going to go back to the way they were. But can I say thanks to everybody. Thanks, Catherine, for organising this. Great to see you all, and stay well.
Thanks so much for making it. So I just want to make one remark, though, regarding this and how pleased the judges seem to be. I was looking at Yulin's PowerPoint, and there's a picture of how judges and hearings are being handled in China. And I see that people are wearing masks. I don't know if they're judges or parties or the attorneys, but that might be a question, is if we go back to what will our new normal be like? I know that at the moment they have to be at a distance, right? So if we open the courts and people actually sit together in the courtroom, will we have to wear masks? That might be a question to be asked. Not in Norway. A lot of people are shaking their heads. I mean, probably not. It would be impossible to then judge of credibility, but I'm just asking that question out loud. Also, the time is moving on. I know some people are dropping out. It's been more than 2 hours, but I'm fascinated by all of your presentations. So I want to keep going, but if you guys have to sort of drop out, or really it's getting late for you and you want to be speaking first, I would understand that as well. I don't know if Vijita is there, but she is next.
Yes.
Vijita.
Yes, I'm here. Yes, so good evening and good morning, everyone. Nice to see everyone. So I will be really, I think, quite quick. So actually, I could say that we are quite litigious in Lithuania, and we have quite many cases, civil cases in our courts. And actually, I can also say that our courts were quite modern also till the pandemic. So we have already for 7 years electronic case. Most our procedural documents have electronic service to the parties and to the court and etc. So it was, and actually it was possible already it has been possible already for 7 years to have video conferences in civil cases. But actually I can say that it was really used seldom till the pandemic, and it was really not popular to use that, and the judges really did not want to use it, and the parties were a bit against that, not for cross-border cases but for national civil cases. And of course everything changed when the lockdown was introduced. So in Lithuania, lockdown was introduced on the 16th of March, and now we have like an exit strategy, and we have like the rules are much more. We did not have actually really hard lockdown. We could walk on the streets and etc. So, but of course, courts from the 16th of March did not work in court sessions and in court halls. And actually, so far as I've heard, so the situation is quite similar to Holland's situation, Netherlands situation in the Netherlands. So we have really quite similar rules, I could say that nowadays. So actually, and this week is the first week where the courts have court sessions in the courtrooms, if it's really necessary. If we really cannot hear that cases in written procedure or online, we can use already court halls. And I can say that masks are mandatory for nowadays in the court sessions. I don't know how long it will be, but now the masks are mandatory, and the judges and also parties and attorneys at law also wear masks in courts during court sessions if they are in the court, and also all social distancing rules are applied. So regarding online cases, so actually not all the courts had all the programs to do video conferences, and not all the judges could work from home. So we bought licenses from Zoom and Microsoft Teams. The courts could decide which license we buy, and we use Zoom or Microsoft Teams platform for civil cases. And some cases actually were adjourned till June or July, which such cases where parties did not agree to have online hearing, and it was not possible to organize somehow online hearing. But actually quite a lot of civil cases were heard online, and actually, as also I can say that, as I heard, quite many parties were asked how we liked this procedure and how was it everything. So actually most parties were satisfied with the procedure, and we said that it's perhaps much better than to sit in the court hall and to have this court procedure in the court. So actually I think also this pandemic will help to modernize our attitude towards civil proceedings, and online hearing, remote hearing will be used quite much more also in the future. Regarding civil cases, regarding pandemic, so far I have not heard any cases regarding With pandemic, also, of course, we have quite many cases regarding bankruptcy or regarding business relations, debts and etc. But regarding like real pandemic cases, we do not have it till now. So perhaps that's it. I don't know what else.
That's great, Vijita. Thank you very much for this information. That's very, very interesting. Let's move on to Jordi.
Hello. Well, nice to meet all you. Well, I also see familiar faces, so I'd like to greet everyone here. Well, the situation in Spain, I mean, just to answer the questions that Catherine did to us. Well, here we had the lockdown declared with the state of emergency at the beginning of March. That means we suspended deadlines, procedural deadlines. In the future, we will be only allowed to have remote hearings. Well, the first urgent one was 2 days ago. And we also imposed these traditional, that are beginning to be traditional safety measures for face-to-face trial. I mean, distancing, personal distancing. I don't like to talk about social distancing. It brings me to other realities, no? But personal distancing, masks. Well, the government talked about simplifying some proceedings, above all, bankruptcy proceedings, family proceedings as well. They spoke about promoting ADR and, well, nothing focusing on COVID-related litigation has happened up to now. But well, apart from that, I don't think this is so interesting. I think the most interesting thing coming from Spain is that we are really facing a collapse of judicial processes after 2 months of lockdown. And the problem is that the situation is maybe going to last, because we don't know how long will the situation last. We talk about herd immunity. We hear a lot of news of the virologists, of the epidemiologists, but no one seems to know what is going to happen next. So I think we have to get used to this situation and, well, trying to planify how are we going to face this situation if this is going to last. And that's why I will give you some ideas of how we could handle this situation. Well, relating to civil procedure, I think when we talk about orality, we were referring of a judge watching witnesses declaring, and that was the only important thing related with orality at the beginning of everything. Then orality started to become a myth, so to say, and well, maybe now handling with orality is not the best idea with remote hearings. I mean, the first remote hearing here in Spain was 2 days ago, and well, yes, you could say that it was okay, that nothing happened, but I mean, couldn't we do the same thing with a written procedure? Well, I think we really could. Because also we have to take into account that maybe witnesses do not bring too much to civil procedures usually. In criminal procedures it's different, because you usually don't have any more information than witnesses and some other evidence. But in a civil procedure, witnesses are not so frequently called. So maybe we could celebrate only a remote proceeding, and we shall regulate our proceedings in the future as if they were only to be remote hearings to be celebrated. In order to do that, I think we should stop the bureaucracy of our proceedings, because all this bureaucracy comes from the past times where there were no recording machines, we had no cameras, we had nothing. We always needed a document to confirm the reality we saw in the proceedings, and well, we don't need anything about that. So just to summarize what I wanted to say, I think we shall rethink all our proceedings, because all our laws were thought when face-to-face trials were possible. But now face-to-face trials will not be possible in some time. So we have to imagine how things will be, or are, or even are, in this moment. And we have to make a new regulation about that. That means maybe we have to wave to our beloved tradition. Jurists love tradition, as you all know, and maybe we shall change many things. And this tragic situation of COVID-19 is maybe one good occasion to do so. Thank you very much.
Thank you, Jordi. Absolutely. I think it's about most certainly changing our traditions and rituals. And you're right that it might need a lot of imagination in terms of changing the rules. I was going to invite Laura, but I think Laura is not here. And what I would like to do is then give the floor to my doctoral student, Shana, who is there with us and has a 2-minute comment for us. So here's an introduction to Shana.
Hello, everyone. First, I'd like to thank my supervisor, Professor Pichet, for inviting me to participate in this outstanding conference. I sure have learned a lot today. Professor Pichet has already well described the actions taken by Canadian courts to adapt to COVID-19 crisis, in particular regarding the uses of technologies. And I also understand that you will receive Professor Walker's material on the subject. So I will not repeat that. I'd like to say a few quick words more specific to Quebec. One of the guiding principles at the heart of Quebec's Code of Civil Procedure is the parties' duty to cooperate with each other in the conduct of litigation. And while the meaning of this cooperation duty is still unclear in practice, we understand that it will increase in importance with the COVID-19 crisis. So I want to share with you all a specific declination of this principle mentioned by Superior Court's Chief Justice at a recent conference about COVID-19, during which he invited practitioners to work together towards procedural consensus, or in French, consensualisme. It means, more specifically, that if parties agree to it, they can waive some procedural rights in order to facilitate the conduct of proceedings, as long as these rights are not of public order. So for instance, the parties could agree to set aside the existing rules on notification of proceedings in favor of simpler paperless solutions, because here in Canada, we're not paperless. They could agree to act within shorter delays. They could even agree to proceed without oral arguments, so exclusively on the basis of the file, which is quite far from our oral tradition here in Canada. So this idea of consensualisme, or the search for a consensus, was tested and worked really well previously in a huge mass litigation construction case in Quebec. In this case, in order to achieve a faster resolution, parties had negotiated, with the help of the judge, a judicial contract with rules specifically designed for the case. And keyword here, I think, is agreement, as opposed to orders imposed by courts. Maybe it is easier to overcome this idea of rituals, this cultural resistance issue we discussed earlier. And we hope that this collaborative search for procedural consensus could be helpful to deal with the delays that will be experienced by the court, as well as the wave of cases and maybe mass litigation that may result of COVID-19. So it's interesting to observe that courts seems to rely on the help of actors, the help of practitioners, to help face the consequences of this COVID-19 pandemic. Thank you.
Thank you, Shana, for sure. That's a very important principle. I'm moving on to Elisaveta. Please, thank you.
Merci, Catherine. Since we were talking about masks, I want to show you one of my fabulous, colorful, washable masks. I have a variety of them. They have a pocket for the filter. So since here in Italy, we must wear masks everywhere, except when we are in the open, and disposable gloves, many women decided to move to these colorful disposable masks. Very happy to see you here, because it means that if you're here, you're in good health, and that seems to be the most important thing right now. So to set the scene, I must tell you that the Italian justice system was shut down at the end of February as a consequence of the national complete lockdown that we experienced. Only recently this lockdown has been softened a little bit, but it's very controversial because the number of sick people has gone up again in the last week. So we really don't know exactly what is going to happen. With that said, I should begin by making reference to a few new rules recently enacted. In line with these new rules, Italian courthouses officially reopened on May 12th. All deadlines had been suspended, but on May 12th, the so-called phase 2 began, and a new window of time began to run. According to the new rules, judicial activities now may resume and continue until July 31st. It's important to underline that for the whole month of July, deadlines and any proceedings that are not considered urgent are stayed. This is not a rule that was enacted now because of the pandemic. It's a rule that has been in force in Italy for a few decades. In practice, the normal operation of the judicial machinery is supposed to resume on September 1st. And this holds true most of all for new cases, the one for which the first hearing hasn't been scheduled yet. So in practice, if you commence a case today, the first hearing will be scheduled and expected to take place only after September 1st, with the specific date initially unknown. So you file the case, you know that the first hearing will take place after September 1st, but you don't know right now exactly when. For cases already pending, the rules in force entrust the presiding judge with the power to adopt all the measures that are necessary for the management of the court's caseload. Among the measures to be adopted, the most important ones are the mandatory protocols devised by the presiding judge and the local bar association. And these very protocols are the major source of inefficiency and confusion. Why so? Because the Italian Lawyers Professional Association has counted no fewer than 200 different protocols adopted for the management of different types of disputes in different courts. courts of first instance, courts of appeal, justices of the peace, you name it. Browsing through these protocols, one understands that essentially the development of pending cases take place in two forms: remote hearings and the so-called paper hearing, which is a fiction because there is only an exchange of written briefs and motions submitted through the technologies of online adjudication. Remote hearings can take place via two platforms, the only two platforms authorized by the Ministry of Justice, meaning Skype for Business or Microsoft Teams. The incomprehensible rule is that the judge must be physically present in his or her own office, so in the courthouse, while the parties and their lawyers can be elsewhere and in their office, at home, everywhere. Here, I would like to emphasize the negative attitude of many insiders, scholars, judges, lawyers toward the virtualization of justice, which is considered acceptable in an emergency situation, but is thought to be repugnant if intended to become the new normal. To tell you the truth, I do see some problem with the remote hearings, for first and foremost with the principles of open justice and public access to the courts. Yet what I consider the most serious shortcoming in the public debate right now is the virtually exclusive concern given to what is happening right now, without much thought at all given to the future and the flood of new cases that will overload the court's docket. The only saving grace, if I may use this phrase, is a renewed interest in mediation, excuse me, and collaborative law. As far as mediation is concerned, if all the parties agree, then mediation can be held online with remote meetings. It will be interesting to see whether extending mandatory mediation or assisted negotiation, which is the Italian version of collaborative practice, will be included in the measures that the legislatures will have to adopt sooner or later in order to cope with the anticipated torrent of coronavirus-related disputes. As for collective redress, I must emphasize that the entering into force of the new statute on damages and injunctive class action has been strategically postponed to November. I say strategically postponed since the new rules would dramatically extend standing to sue, as opposed to the present rules granting standing only to consumers and users. Obviously, the present emergency would offer the perfect scenario for every possible form of collective redress, but according to the rules, still impossible. I cannot foresee a real surge in the number of group actions. And I'm almost certain that the entering into force of the new rules will be postponed far beyond November, specifically for this reason, to reduce the avenues, the possibility of a surge and high number of class action cases. That's it. Thank you.
Thank you very much, Elisabetta. So have you seen, I hope I didn't miss anything, but have you seen more of the COVID litigation coming?
Not yet, not yet, but it is expected in the field of contractual dispute, labor disputes, many disputes before administrative courts for the responsibility of the nursing home, where we had a very high number of dead people. You know, our death toll is very high. It's 31,000 people that die in Italy because of the coronavirus. So there will be a lot of litigation, and my concern is that legislatures seems unable to see the problems that are coming, and so.
Yes, that's a good point. Well, it looks like.
Catherine, can I interrupt? This is Rick Marcus. John Sorabji mentioned something. I think Elizabeth also mentioned something related. From my perspective, the shoe that has not dropped is challenges to the legality of the measures that have been taken and may be taken. So just as a footnote, I think that's something else that we can anticipate. I think John said there has been at least one in the UK. I expect, particularly on immunities that our legislatures are adopting for nursing homes and others, we're going to see a lot of that here based on the right to jury trial of claims of that sort. I haven't been hearing that from others. I don't think there's time to talk about it, except to note that that may be part of our future too.
That's true. That's a good point. Okay, time is passing by. I have Bart, if you want to say a few words.
Yes, I'm here. Thank you very much, Catherine. I think most of you will be happy to hear me speaking, not because it's me, but because I'm the last hurdle between you and some free time. And Elisabetta, it was so funny that you just took your own face mask just some minutes ago. It made me realize that in Dutch courts, Dutch lawyers do have to wear this, and I used to be a practicing lawyer, I still have it. It was already suggested that Dutch lawyers simply do this. So they can use it as face mask instead of their gowns. Let me just tell you some things about the Dutch situation. I already wrote it rather extensively on the report published in the Tromsø, by the University of Tromsø. I will not repeat everything I wrote over there. Just 3 remarks, and I'm very well aware of the fact that I am the last hurdle between you and the drinks Catherine has organized for us. So first of all, I think all the presentations today made it very clear that COVID is affecting civil courts seriously. And one of the concerns you can hear in all the presentations today is the concern of backlogs. And Richard very well also raised the topic of the validity of some measures, but the topic of backlogs seems to be, well, all over the place. For the Netherlands, we have to make a distinction between the Supreme Court on one hand and the lower courts on the other hand. Supreme Court, business as usual. Almost business as usual. The only thing that might be different than in other times is that they work from home. But we see the decisions every week. It's almost nothing special. They even have a statement on the website of the Dutch judiciary how they work from now on, and it comes down to it, almost business as usual. For lower courts, there's a big distinction. As I already wrote, backlogs are increasing and increasing for certain type of cases. For cases which there will be a hearing or a deposit where there is some need for physical contact or face-to-face, there the backlogs are increasing. But for other type of cases, judges do finally have time to write their decisions, to work on their backlogs. So there's there's another number of cases where the backlogs are seriously decreasing. So it's just a shift from one type of case to the other type of cases. So backlogs are increasing. That might be the majority, but for other type of cases, backlogs are shrinking as well. Remark number 2, technical options. In the Netherlands, there were technical options before the pandemic, but not very well used. They were quite limited. It is rather obvious that in these COVID times, technical options are being used much more and more, both on emailing and on perhaps sometimes even by phone or by video conferencing or by hearings or by deposits. It is being used these times much more and more. Will it be the new normal? John was quite positive about it. Alan was doubting it, whether it would be the new normal. I think for the Netherlands, it might turn out that it will not be the new normal, but that at least some aspect will be not just temporarily, but at least some aspects will turn out to be, well, more permanent. I'm not sure. I have 2 reasons to think so. First of all, my impression is that Dutch judges and Dutch courts are quite practical. They are quite practical in their approach. So if they experience now it works out well, why putting it away? Why putting it away something that works for now? But there's another reason that it might turn out to be, at least for some points, to be a bit more permanent. That is the fact that we had a large project on digitization of civil proceedings. That project was put on hold more or less last year. That did not primarily concern video conference, etc. It primarily concerned the way communication between lawyers and the courts, but that project was put on hold mainly for technical reasons and for budget reasons. That was put on hold last year. The decision to stop that project was criticized heavily by lawyers. It might very well be that the current experiences will be an emphasis to revitalize that project again. So perhaps that might be a reason not to, might be a reason not to be afraid that it will all fade away. Third remark. For me, it's quite obvious the fear we have heard from many of you for new cases. New cases on insolvency cases, labor cases, as Elisabetta mentioned, perhaps eviction cases from houses, contract cases, will it be force majeure, unforeseen circumstances, etc. It is far too soon, at least for me, to tell what this will mean number-wise, but it's clear that COVID will affect civil proceedings, civil cases, both on B2B and on B2C. That's quite clear. And you asked, Catherine, in your invitation for this well-organized event, can we shed a light to the future? At least that's how I understood your question. Is there a Harry Potter wand to deal with the backlogs, and is there a way to cope with it? Well, let me just mention one topic which I haven't heard very much so far, which will absolutely not be the Harry Potter wand, at least in my view, and that's the relevance of substantive law. Some people suggested, perhaps in writing, but I've heard the suggestion sometimes, that there can be some new acts concerning substantive law. For example, stating COVID cannot be considered as force majeure. COVID cannot be considered as unforeseen circumstances. COVID can be considered as reasons or ground for validity or non-validity of a contract. That might be an idea, but to be honest, I'm not really positive about that suggestions. Might be good ideas for some types, and from a substantive point of view, that might be a good idea, but I don't think it will diminish civil proceedings very much, because new legislation will always lead to new cases. And one of the main problems with such acts might be the topic of causation. Because if we say force majeure will not be ground for, COVID will not be ground for force majeure, then the next question will be, was it really COVID? Or are you using COVID as an excuse to get rid of the contract you wanted to get rid of anyway? So perhaps there will be some new acts. I've heard that some countries over the world are considering it or have already introduced so. It will not be the magic wand for handling the backlogs. There's much more to say about the Dutch situation, but I will not do so because as far as I'm concerned, we've all deserved our free time now. Thank you, Catherine.
Thank you, Bob. This felt like a good conclusion. I did promise some questions, so I don't know if there are any questions or comments from. We haven't. There's some of you we have not heard from, and you're most welcome to participate in a form of question or comment. There was Wolfgang or Alesh, Federico. You may raise your hand, you may not raise your hand. This is not a test. Otherwise, I will say some concluding words, but they'll be very, very quick. And actually, it's not nighttime for me. It's only lunchtime. So I will not have a glass of wine just yet. But maybe, maybe as a conclusion again, and I don't want to repeat what you said, Bart, because I think you were absolutely right. I think a big change has happened. And it has been a change forced by the pandemic, for sure, by the state of emergency. I think there may be many more lessons to be learned from looking at the past and how others have dealt with catastrophes and crises, and be it I'm thinking of earthquakes, I'm thinking of 9/11, I'm thinking of many other types of emergencies that might have forced the way we do things, forced a change in how we do things. Now the pandemic has forced change on our courts and has...
Catherine, this is Rick. I'm sorry to interrupt, but one other thing that I have been thinking about in the US is, you mentioned earthquakes, 9/11, we have had those things too, and hurricanes. Are all emergencies like other emergencies? This is a pandemic. Alan experienced an earthquake. Maybe responses to one emergency are going to be really different from responses to a different emergency.
That's a good point. And also, I guess the reason for it is the length of the emergency, right? The duration. In the case of earthquakes or 9/11 or other types of short-term emergencies, the response might be different. So you're absolutely right. In this case, for some of us, we're excluding the UK, but for, I would say the majority of us, our courts have been not active by and large for a few months. And this is extremely problematic in light of access to justice. So definitely all our rituals are being shattered as well. And so I think perhaps John's perspective of the UK is the most refreshing in many ways, because the UK has just decided to plow through this and keep going. And from what I understand, it is not for lack of existing rules and possibilities. It's not for a lack of technologies in all of our court system, in all of our countries. We do have the technology, we do have the rules allowing the use of technologies, but we just have not made such a big change. So I think what we need to do from now on is to keep monitoring the response as well, and to keep sharing our views and sort of appreciating how this is all working in our jurisdictions, be it the degree of satisfaction of the users, how the courts are feeling about this and are working through this. What we also see is that for some countries, there really has been a rise in litigation, and for others there hasn't. And maybe it's because you have other systems, better regulations. Maybe it's because you have more ADR. We haven't spoken that much about ADR. So there are various solutions out there. I'm not sure there's that much to add, and we've kept going for quite a while, so I think I would just leave it at that. And if you guys I haven't looked at the chat box, but if you do have more comments, that would be great. And otherwise, I will encourage you to share information through email. Email is probably best at this point, because I'm not sure we can save the chat box. Maybe before we close off, you might want to sort of save what's been shared in the chat box. And otherwise, we'll share by email and we'll keep in touch. And maybe in a few months, we can have another of those meetings. So thank you very much, everyone. And I hope to see you again very soon. Take care and be safe.
Thank you. Bye-bye. Stay safe.
Thank you. Bye.
Thanks.
Bye to everybody.
Thank you.
Thank you.
Bye-bye. Thank you.
Bye.
Bye.
See you guys.